Okay, good morning, everybody. Welcome to JLCAR. Um, Senator Gray, you can sit in for Senator Lang, who is not going to be here today. And Representative Grassi, you can sit in for Representative Schmidt, and Representative Hacken Phillips for Representative Leon. I'm right here. Well, there's Representative Leon. In that case, you're in for Senator Whitley. Okay, wow, full crowd today.
Yeah.
All right. Meeting of the minutes of the previous meeting. Does anyone have a motion?
Move to approve. Second.
Any corrections, changes, or comments? Seeing none, those in favor?
Aye.
Opposed? All right. Is there anything to be taken off the consent agenda? All right, in that case, is there a motion?
Move the consent agenda.
Second.
It's a tie between Senator Ennis and Representative Lim.
Defer to the representative? No, I'll defer.
All right, Representative Lim gets the goal. Any questions, comments, discussion? All right, the consent agenda, those in favor?
Aye.
Opposed? Okay, moving right along. Is there anything to be postponed?
Yeah.
Yes,
Yes, letter B to 2023-236.
right, from education. Does someone wish to move that?
Second.
All right. Moved by Senator Ward, second by Representative Groda. Those in favor?
Aye.
Opposed? All right, that's postponed. It's starting off with explosives. How nice.
Yes. Yes, so this is proposal 2023-184, the Department of Safety's rules on explosives. The only comments I had on this particular proposal were two notes to the committee. The first has to do with the dates, effective dates on the forms. Most of them say April or May of 2013, excuse me. And because forms are rules, they do have a 10-year expiration date, just like rule text does. However, after speaking with the department and looking at our old files, it does seem like all of these forms were part of the 2013 rulemaking process, and those rules did not go into effect until August. And this proposal was filed before the expiration date, which stays the expiration date for all of the rules. So I just wanted to bring that to the committee's attention. We are working on the manual, and that's something that we'll try to clarify in the manual, that effective date of forms needs to be, or when exactly the agency should be putting the effective dates of forms. The other note that I had has to do with 4 of the forms. The first is on page 7, which is DSSP 84, and the other 3 are on page 9. All 4 of these forms originally had had required a social security number. And after looking at the statutes, I did not see any statutory authority for that, which would be in violation of RSA 541-22. After the agency submitted their conditional approval, they made that requirement a voluntary request. And so even though they're not requiring on the form, it is still something that they're asking the applicant to provide, even though it's voluntary. So I just wanted to bring that to the committee's attention.
Yes, could we have a comment on that?
Good morning. My name's Marta Moltiani. I'm the representative for the Department of Safety, and I have Trooper Flynn from the Explosives Unit, Division of State Police as well. When I inquired of the Permits and Licensing Unit who processes these applications, it's more of a customer service in the sense that when an applicant comes in and they provide their name and address, and some of them are from out of state, they do a background check, and they also check the state from where they're coming from. And it's a means, if somebody has a very common name, of being able to ensure that it is the same person, rather than just simply denying them based on something that the record displays and it's not that individual.
Questions, concerns? All right. Anything else?
And that is all I had for this proposal. As I stated, it is a conditional approval. So the committee can either approve the conditional approval or enter an objection at this time if they feel it's necessary.
Representative Beretta?
So I am concerned with the voluntary divulsion of social security numbers. And I'm wondering if there's some other information that could be given in addition to someone's name and address from an out of town. I'm not comfortable with that.
Understood. I don't know how to respond to that, other than absent that, there's no way to ensuring that the record belongs to that individual, and they would just be denied until they were able to prove that they were that individual with that record.
Question.
Lynn?
Does the form ask for date of birth? I mean, wouldn't that
Yep.
be a basis to, even if it's John Smith from New Jersey, presumably it would be, if the date of birth would seem to be a big way to narrow it down.
That's a very good question. So I'm told that they look for 3 indicators to match, and date of birth is one of them.
Okay.
Okay. Other questions? Director Morrow?
Thank you. I do know that there are at least a few agencies in certain rules who ask for, request, but do not require social. I also have seen a few instances where they request just the last 4 of the social. Whether those conform with the law is debatable.
Okay. Senator Gray?
I'll second that. I was on the board.
All right, moved by Senator Gray, second by Senator Ennis. Comments, questions? Seeing none, those in favor?
Aye.
Opposed? All right, thank you. No. All right, prime wetlands.
So there's only one comment on this conditional approval, and it's an interesting issue. The statute gives the commissioner the discretion to authorize a 40-day extension for good cause shown that would allow municipal conservation, local river advisory committee, or the New Hampshire Rivers Council more time on their application. The issue is there's just no rules regarding what good cause shown would be. And so either it needs rules or it needs a legislative fix. We just thought it was a little unclear as to when this extension would be given.
Okay.
Good morning. I'm Courtney Lockwood. I'm one of the staff attorneys at DES. So we actually removed from this chapter the reference to that statutory provision in the hopes that that would fix the situation. It's not necessarily that we're saying good cause doesn't need to be defined or explained in some way. It's just that this is not the chapter to do it. So wetlands has 10 chapters of laws, of rules in order to, for someone to get a permit when they need a permit, that sort of thing. This chapter is only for prime wetlands, which is only certain permit applications. And so if we were going to define it, we would put it into chapter 300, which applies to all permit applications. So at this point, for this chapter that's before you, we don't reference that statutory provision, and it just also wouldn't be the appropriate place to explain what good cause is.
Okay, so does that answer your concern?
Madam Chair,
Mm-hmm.
because our court reporter is not here today, I would ask that anybody that comes to the table, regardless of whether they testified, please fill out a pink card.
Oh, sorry.
And yes, that does answer the concern.
Okay. All right. Senator Gray?
Question, do you want that approval to be conditional based on them adding the item to? And so I'll make that motion that we approve on the condition that the department seek to change, I think you said chapter 300, to include the necessary reference.
I'll second that.
Okay. Any further comments, questions, discussion? Those in favor?
Aye.
Opposed? All right, thank you very much. All right, OPLC.
Okay, so this item was postponed from the last meeting. It's the licensure and discipline of regulated profession, the PLC 300 rules. There's been a conditional approval request and an amended conditional approval request filed, and most of the issues have been resolved. There are a few that remain, and those are on the final proposal packet. So, and if you go to that packet, you'll see about 3 pages in, there is a memo to the committee kind of describing what those remaining issues are. So I won't spend a whole lot of time on them. 2 of the issues are basically informational notes to the committee, which you've heard about before, and that's around the and that should be addressed this legislative session, and that's around the term of the licenses when they expire, and then the other issue is around the administrative fines, in that some boards still have administrative fines within their practice acts. There is one legislative comment that you'll find in a couple of different places, and it's on pages 11 of the final proposal, or page 17 of the final proposal packet, page 26 of the final proposal, or 32 of the packet. So it's the same legislative comment. The rules would allow the OPLC's licensing bureau to make a determination on whether to approve or deny a license application without input from the applicable board if that board doesn't respond to the OPLC's request for feedback on that application within 50 days. As you may know, some boards don't meet regularly, some meet quarterly, for example. RSA 541A 29 requires agencies to approve or deny applications within 60 days. So the OPLC is within that, that time frame. But what we were concerned with is that the rules may not adhere to legislative intent, and that's because the statute for OPLC describes that the OPLC is supposed to consult with the boards. And so it's unclear whether sending a request to the board like this qualifies as consulting with. And so we're not sure what the legislature had in mind around, consulting, what that's supposed to look like. And so that's, we weren't really sure if sending the notification in this way qualifies as consulting with the board. So we thought that you might have some questions about that. Before I close, I'll say that the issue also somewhat impacts the next proposal on the agenda, the PLC 313, which are receiving some cards on that. We didn't have any comments on that proposal, but the reason why it's not on consent is because we did get some testimony expressing concern that the OPLC is not actively consulting with the boards. And so, but we note that in conversation with the OPLC, what we learned was that in preparation for those PLC 313 rules, the OPLC did solicit for feedback from all of the impacted boards and gave them a timeline to do that. So anyway, we're just not sure what consulting with is supposed to mean, what the legislature had in mind. And so that's the issue that remains with this proposal.
Okay. Representative Groda.
The EDNA committee spent significant amount of time in the last 2 years with amending the statutes for OPLC. And it was very clear to the committee that OPLC is not to operate independently from the boards on some matters. And so the in consultation with the board means that they are to include comments from the boards on any actions that they take, where that's written. If that needs to be further defined, we can do that. But there was no timeline, there was no method for that process. One would think that OPLC would discuss these things at board meetings, for example, as opposed to just doing this electronically through emails. It has to be a sincere effort.
Director Courtney.
Thank you, Madam Chair, members of the committee, Lindsay Courtney, Executive Director, OPLC. I think our legislative authority is pretty clear, and actually our responsibility is to issue licenses in accordance with objective standards established by the boards. That's the criteria that was established in both HB 2, 655, and 409 of last year. So we are doing that. I think what we're finding is that there are some rules that are not necessarily objective, and then typically what we find is that with respect to criminal history records checks, we don't have clear delegations of authority or standing orders from the boards stating, these particular crimes could be something that's substantially related to the practice, and so therefore we want to have a show cause hearing. So that's where we're finding the issue. What's also clear under 549A 29A is that the agencies, whether it be the board or the OPLC, have to act within 60 days. And so our position has always been that the boards, in addition to OPLC, have an obligation to do their job, which means convening a quorum of the board if there is an application that needs to be reviewed. I don't think it's appropriate for a board to essentially hold hostage the application process by not meeting. And I actually think that the statutory language is quite clear that if they don't meet, then there are some decisions that are made by operation of law. So we don't find ourselves in that position very frequently because most boards are committed to doing the business that they have been entrusted to do by the legislature. But our position is that under the rare circumstances where boards cannot meet in a timely fashion in order to adjudicate an application, then the agency is obligated to act pursuant to 549A 29A.
Questions, comments? Senator,
I think this discussion.
turn
here-
your mic on, please.
I think the discussion here is wonderful, but I think the real solution is to approve with the condition that they seek legislative solution to this, because the wording as it is right now, is at least confusing our people, that are reviewing this. So I move that.
Okay,
I'll
before,
second.
all right. Moved by Senator Gray, second by Representative Groda. I do have a public comment on PLC 300. Oh, that's from Director Courtney. We've already heard from her. The others are on the 313s. Okay. Any further comments?
Yeah, the only
questions?
thing, I'm certainly prepared to support Senator Gray's motion, but the only other thing I'd say is it seems to me that the explanation given is a good one. There's not, unless I'm missing something, there's nothing, even if a board normally meets quarterly, there's nothing that prevents them from meeting more often if they have work to do. And so it seems to me that your position is valid. You send them something saying, here's we've just gotten this application. Now their job is to meet. And if it's, if that means they have to meet more frequently than quarterly, well, that's the way it goes. So I think that's a perfectly valid explanation.
Yes. How often does such a application come in that is obviously correct with say with a clear criminal record. Do you consult with the board in that case?
Depends on the board. So the Board of Nursing, we do often have findings on criminal history records. They've actually done a matrix that tells us exactly what to do. If you have a history of this, then this is what you do. If you have a history of this, then we want to see it. And they meet very regularly, at least once a month. Other boards where we have positive findings on criminal history records checks, they do not have such a matrix. We're working with them on trying to develop that. And so essentially, as the applications come in, we upload them into the agenda and say you have applications that need to be reviewed, which means you can't conduct a meeting electronically. We don't do this business via email because that's a violation of 91A. What that means is that they have to schedule a meeting.
But with a clear criminal history, you would process the license without necessarily consulting with the board. Is that correct or not?
No, only if the board has set forth in a standing order or a delegation of what they would like to see. Because the challenge is under 332G, first of all, the board has to prove by clear and convincing evidence that the person is more likely to reoffend with the license. So we can't, unless we have some sort of delegation, we can't make that showing upon a review.
Okay, so that unless the board has decided that this is okay, you don't just process the license.
Correct.
Okay.
Correct. Unless they don't meet. And if they don't meet, then we need to move forward.
Okay, thank you. Representative Fellows?
Yes, thank you. I'm wondering if you can tell me how often this issue is coming up when it's not a criminal records check, and also how much is there a specification of how much lead time you're supposed to give the board to respond and to meet?
So the rules that are proposed here are intended to comply with 541A 29, which means that as within 60 days of receiving a response to a request for information, the agency has to act and either approve or deny the application. So as soon as we get the complete application, we essentially upload it into our electronic system. You know, most boards have a monthly meeting, so they're going to be seeing these in a timely fashion. It's just the boards that don't meet regularly, meet quarterly, meet once a year, meet twice a year. That's the challenge. With respect to whether we see this on other matters not involving criminal history records checks, it's not typical because the boards are supposed to have objective standards. There are some boards that still have subjective standards, still have essays and that sort of thing, and we're working with them on those.
Okay, other question, Representative Baroda?
So I just want to support the motion that Senator Gregg made, because this kind of conversation is not one that we had intended when we reviewed all those amendments this summer concerning the authority of the board to issue licenses. So I do think that we need to look at the legislation on this to make sure that we haven't somehow unintentionally made it more complicated.
Okay, thank you. Director Morrow?
I have somewhat of a concern. I understand that the process that Director Courtney mentioned as far as the board interacting with OPLC and setting standards for OPLC to act, but I'm concerned whether or not those things that the board is telling OPLC, if this happens, then it's okay to approve. If they don't have, if this is negative, then do not approve. Whether those items are actually in the board's rules.
I don't believe so because I haven't seen them, but Director, you have a comment on that?
They're not in the board's rules. I would say if that's the position of the committee, we can certainly work with them on that. We have used these guidelines on advice of counsel over at the Department of Justice for many years. If we are required to send every application with a criminal history records check to the Board of Nursing, for example, that is going to be that's going to be a lot of work. So I think there's some practical issues here, and we'd be happy to, if that's a directive of the committee, we'd be happy to work with them on rules. But we have been operating on advice of counsel for quite some time.
Comments, questions? Yes, Director Morrow.
I think this is my concern is limited because presumably each of the boards have criteria in their rules for when they're going to approve or not approve of a license. The concern is simply if they add something to that when they talk to OPLC that is not in their rules, which
Well,
is hypothetical.
From the comments, it appears that it's a matter of how to evaluate an imperfect criminal records check. And that is something that each board has to decide for themselves.
I was just going to echo Director Morrell's comments, to the extent that these matrices are, have requirements that are different from the rules or that they should be in the rules, then they need to be in the rules. But we don't know that until we see those matrices.
We'll take that under advisement.
Not to continue to add to the confusion, but there's a lot of crimes, both statutory and under common law. And so what we find is that, there are certain buckets that I think the boards can give us direction on. And the issue is whether the matter requires consultation. That's the issue. So what they've said to us is you don't need to consult with us on these issues. The rest does require consultation, and we leave those to the boards. I think, and we can certainly talk offline, but I don't know that it would be possible to put every potential crime into a rule because there are many. And then there's aggravating and mitigating factors that we could potentially not consider in that process.
Right. So the board could, for example, say you have a 20-year-old possession of marijuana. We're not going to worry about it. If you've got a current fentanyl with intent to sell, we definitely want to talk about it.
Right, right.
Well, just off the top of my head, thank you. All right, any further comments, questions? All right, we have a motion to approve with consultation,
And that would be with conditional approval.
conditional approval, yes. Those in favor?
Aye.
Opposed? Okay. All right, PLC 313. We do have some public comment on that. I think we'll hear from the staff and then the public and then Director Clark.
Yes, I have no comments on this proposal. The public testimony that I received for it talked about the OPLC not consulting with the Board of Acupuncture, but it appears that they were given notice with a letter first, and then were consulted with for 45 minutes about these rules. Excuse me. So it did not affect my analysis of possible reasons for objection.
All right. Thank you.
If I could add one thing, in taking a look at that testimony and the letter that the OPLC sent to the acupuncture board, Director Courtney did let me know that that same sort of letter went to all of the boards prior to them filing the initial proposal. And so they did actively seek out feedback from the boards on those rules.
All right. Thank you. Michael Pelletier.
Good morning. So I just have a comment on the proposed, I'm sorry. My name is Michael Peltier. I live in Hillsborough, New Hampshire. And I have a comment on the substantially similar rule for the plumbing board. Is that, okay, we're on target. I remotely attended the board meeting last week, and what the proposal, as I understood it, was is if another state has the same year or subsequent year statewide adoption of the same plumbing code, the International Plumbing Code that New Hampshire adheres to or has adopted, it's presumed to be substantially similar. What my concern is in that respect, if New Hampshire decides, for example, later this year to adopt the 2024 IPC, what used to be substantially similar, considered substantially similar in the 2021 code, is no longer considered substantially similar with New Hampshire's adoption of the 2024 code. So what I would suggest is not only the current and subsequent codes be recognized as, sort of de facto substantially similar, but also the previous year's code. One can observe that the technology of plumbing dates back 6,000 years, and if you brought a Roman plumber forward in time to present day, he would recognize the principles of gravity and water pressure and so on. So I think that over the past several years, the technology of plumbing and the rules around plumbing safety have matured, and I think that recognizing perhaps previous year or the previous two versions of the code, as well as potentially the Uniform Plumbing Code, would serve the interests of the legislature in encouraging skilled tradespeople from other states to move to the great state of New Hampshire.
Thank you. I will mention that New Hampshire is deliberately not on the latest version of the codes. We are now contemplating moving to the 2021 code. So most states will be with us or ahead of us. So that, while valid, I think your concern is less of an issue than it might be if we were trying to be at
The latest
the
and
leading
greatest,
edge,
yeah.
Yes. Okay, but thank you for your comments. Any questions? Okay.
Thank you.
Jesse Doucette.
My name is Jesse Doucette. I'm the chair of the mechanical board. And I'm just speaking on the 313 as we're here, but we just talked about it quite a bit in this past meeting. And one of the things that really stuck out to us was giving licenses to pick a state. And the board, we definitely did not like that idea in the sense that we're being held to the same standard as, and no offense, like cosmetology. And what we do is a little bit different. There's a lot of life safety involved. When you're dealing with gas, there's a reason we have a gas law in this state, and it's because bad things happen. We are not making sure that people are being held to the same standard that we do require in the state of New Hampshire. If this is going to be the way it's going to be, we would at least like to see people come in, at least just test, just take the test. If you say you're a plumber and you know your stuff, you should be able to take the test. And the biggest thing that we had a bigger concern on was New Hampshire law, which there should be some sort of a jurisprudence test. And we did vote in this past meeting to actually start putting together one. We were not even aware that that was something that we could do. We are now aware of that. And we would definitely like to see, I guess those would be the two biggest things that great if you have a license in another state, but that doesn't mean you know what you're doing here in New Hampshire. So we would like to see them be able to take the test and then some sort of a jurisprudence test.
Will you, when you develop that jurisprudence test, will you be requiring it of New Hampshire applicants as well?
That is covered in the testing that they take, in the schooling that they take here in New Hampshire.
Thank you. Other questions? Okay. Thank you very much for your
Thank you.
testimony. Ted Evans.
Came prepared. Nice.
He's a pro.
Yeah.
We've dealt with him before.
Good morning. My name is Ted Evans. I think some of you know me from past appearances before you. With me is Joy LeBlanc, who is a owner of a plumbing, heating, and electrical company. And she's here for moral support. So thank you, Joy.
Representing how many heating, air conditioning, plumbing, gas fitters, etc., other companies that are on our committee and on our association with the Plumbing, Gas Fitters, HVAC Association of New Hampshire.
So we attended the hearing on the proposed rules for the PLC 31334, to be specific, with regard to the Mechanical Licensing Board. And we have some comments, further comments, based on the final version that we've seen, we're looking at. The first thing is that we appreciate that the references to the current editions of the code or later was incorporated in the change in the rules. But we do have some suggestions on a better way to say it in that paragraph 1. The original language that landed in the final version was those codes adopted by the legislature in accordance with for residential and commercial properties. But we think the more precise thing to do would be to reference the definition of the state building code in RSA 155A, paragraph 1, 4, and 4A, and the New Hampshire State Fire Code, RSA 153:1, paragraph 6A, where it specifies what edition of the code is currently in law. And we think that's a better way to do that, especially because the legislature is considering moving to the 21 codes, both on the ICC side, the building code, and also on the fire code, which covers the gas. So we think that's a little bit more precise way to word it. We're sure the attorneys on the committee will appreciate that. The term residential commercial is just kind of vague, and the codes that we adopt in New Hampshire include other types of buildings, institutional, storage, things that aren't necessarily referred to be included in residential or commercial. Paragraph 2, we were asking for, at the time, what we thought was some qualifying event to verify the applicant is familiar with the board's administrative rules, especially the 600 rules, et cetera. And the response was that the board does not appear to require a jurisprudence examination, so no exam has been added. Subsequent to that, we found out there's a name for this, a jurisprudence examination. We didn't know that at the time, and the board didn't know that. Now they know it, and they voted to develop one. And our request is that that be included in this final version of the rules, a jurisprudence exam. And when the board has approved one, it'll be ready to be used for that purpose. So rather than delay and make us go through the full rule process for that little change, we ask that that be included.
Okay.
The reason for this, some of the reasons for this is the response said that, well, once they're licensed, they'll be going to continuing education and become learned, or they will learn all about their rules and law in these continuing education classes. But that's really not going to work. First of all, it has to be understood that if an applicant is issued a license from another jurisdiction, let's say in June of 24, they'll be able to operate and practice until June of 26, May or June of 26, before they attend both classes for both years. Yes, there's a class for each year, but they're not required to attend it in that year. They can pick up 2 classes in the second year. That's, I would say, maybe 20-30% of the tradespeople do that. They wait. They don't take it every year. They wait until they have to renew. Oh, I have to get my classes in, and then the providers of this service make both years' classes available. So somebody could be running around without being aware of the board's administrative rules. Secondly, I think it has already been pointed out that the board does have these kinds of questions covering law and administrative rules on their examinations for New Hampshire applicants. So we have to, I think, make this equal and safe at the same time. The part of the reply that said that in any event, the licensee would be professionally obligated to comply with the applicable code. I think that just ignores the public safety aspect of this licensing program. We're installing gas appliances, we're doing plumbing, and some of us do electrical, and there's a pure public safety interest involved that I think should overrule thoughts like, oh yeah, they'll just learn it on their way. So, and just to illuminate, the board's 600 rules called professional standards include things like what we call professional obligations, and that is the things they're required to do. We have ongoing requirements for licensees, advertising obligations, prohibited actions, what they're not allowed to do as licensees. And then in 608, the duty to notify, and this is an obligation to correct situations that are a risk to life safety. And by notifying the owner in writing, specifically, and then if we don't get action from the owner, they're supposed to notify a local official or a fire official of this dangerous situation and remove the equipment from service if possible. So you don't see that in other states. I'm sorry. That was something that was developed by the Department of Safety when we were under them, and it's pretty specific. And I think it really does lead to the aspect of public safety. I think that we think that if this is omitted, that we're going to be creating and fostering unsafe conditions for us in New Hampshire. I'm trying not to get lost here. I'm sorry. We were very inclusive in our comments. So number 4, eligibility requirements for gas fitting licenses. We made a comment that there were no exams required in the rule writing. The response was there are no rules for or requirements for examinations for the gas fitting. We all dropped our jaws when we read that because that was not our understanding. We think that's an error. And the board's rule requires in MEC 30404 under required supporting materials for licensing, in paragraph G, number 3, proof of successful completion of the license exam taken at the end of the courses, the endorsement is being applied. So there is testing. In number 5, we asked for the inclusion of continuing education requirements as constituting the word similar requirements. The response was not reasonable that only individuals from jurisdictions require continuation be eligible. Once licensed, again, they're obligated to comply with the continuing education requirements, and all licensees are required to comply with the codes, etc. But we feel perhaps some additional explanation is necessary. The ICC and NFPA codes, the ICC would be the plumbing code and the NFPA would be the gas code, that have been adopted in New Hampshire are published on a 3-year cycle with new requirements and or change requirements. Is that a jurisdiction might have adopted the same code as New Hampshire now, currently, but the licensee from that jurisdiction may have been licensed years earlier under an older edition of the code, or perhaps some other code entirely that might have been in effect at the time they were licensed. Without some kind of form of continuing education on those changes, the licensee would not have been required to keep up with those changes. It's possible that licenses in other jurisdictions are also issued under grandfathering conditions, which creates more concerns. We have continuing education requirements once they are licensed here, but again, they can be here for quite a while before getting up to speed, and it might take a while quite a while to get up to speed if we're relying only on continuing education classes and the so-called professional obligations. As you might be able to tell, we were not fans of this change in the legislation giving out licenses to other jurisdiction license holders. And we're not the same as cosmetology or massage therapy. Please understand, we have a serious public safety concern here about this licensing, and I thank you. Entertain any questions.
Okay, thank you. Other questions?
Madam Chair, just so everyone knows, if you take a look at page 31 of the FP packet, these comments relate to PLC 313.34.
Yes.
That's on my sheet in the top.
Right, that's professions regulated by the Mechanical Licensing Board. Yes, that's there. Okay, any other questions or comments? Thank you
Thank
very
you.
much for your testimony. Director Courtney?
Thank you, Madam Chair. Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification. So a couple of things I just want to set the stage. The result, these rules are a direct result of the legislation that you folks passed last year, HB 594, which essentially requires the office to issue a license to individuals who are licensed and in good standing in another state with substantially similar requirements as determined by the executive director and rule in consultation with the boards, councils, and commissions. So we, and I think as you may recall, this was very high priority on the governor's initiatives for last year in an effort to reduce barriers to workforce and allow qualified people to enter workforce in New Hampshire in a reasonable time frame. So initially we had some interim rules. We identified several professions, I think about 10, that we thought would have the greatest impact. And we focused on those. We filed some interim rules in October. Those rules have expired as of April 12th. So currently we have no endorsement requirements in the state of New Hampshire. And then what we did is taking our obligation to consult with the boards very seriously is that I went through every statute in New Hampshire and developed a draft of what I thought would be substantially similar based on the statutory requirements. I sent an individual letter to each board prior to filing the IP in October. I asked for feedback and or a meeting, and many boards we did meet with. I did meet with mechanical, I met with acupuncture, I met with many boards who are interested in participating in this conversation. Sometime around January, we filed the IP. Again, we notified the boards. This was our draft, and we invited additional comments. So I do believe that we did everything we could to fulfill the statutory requirement that we consult with the boards, and we did incorporate the feedback. HB 594's requirements are not specific to certain professions. They apply to all professions as long as they're substantially similar requirements. So not only does it apply to mechanical, it applies to cosmetology, massage, but it also applies to physicians. It applies to pharmacists. It applies to also other safety sensitive positions. So the directive from the legislature was very clear. If there are professions in other states that are substantially similar to our professions and our requirements here, we are to issue a license. The statute was also clear that really the only requirement is that they have a license in good standing in another state. We have existing statutory authority to establish fees, so we thought, okay, at least they have to fill out an application and pay a fee. And the statute also said that if the person is required to undergo a criminal history records check in New Hampshire to get an initial license, we're going to require that of our endorsement applicants. There is no language that would authorize the office to impose additional requirements. But what we, and so I think we are taking some liberty with respect to jurisprudence exams, but the position we took with the boards is that if the board has an existing jurisprudence exam, if the laws in New Hampshire deviate significantly or impose additional requirements that people need to be aware of in order to practice safely, we're going to try to put that in the rule. And a prime example of that is psychology or the other mental health professions, where there's differences in the law for practice purposes as to duty to notify, duty to inform, confidentiality requirements. So we thought that was reasonable. That said, I think an argument could be made that we don't have that statutory authority. So that's the position we took with the boards, that if you have an existing jurisprudence exam and it is based on specific New Hampshire law and not just a smokescreen for another licensing examination, then we will add that. So that's basically how this played out. Originally, with respect to mechanical, we didn't have a requirement that the code be the same edition or later. That was added after we consulted with the boards and at their request, and I think that's reasonable to do so. But the Mechanical Licensing Board does not currently have a jurisprudence exam. I would be happy to put that in the rules if and when they develop a jurisprudence exam that applies to all applicants. But if we were to add that in the rules now, I think that would impede our ability to actually issue licenses under PLC 313s because they haven't developed the licensing examination. So my suggestion is that if and when they do develop this JP exam, and it is specific to New Hampshire law, that we go back and we open up the rules again and we add that requirement to the rules. I think that's all I wanted to say. So thank you.
Okay. Senator Gray?
Was wondering if they've got any comments on this side of the room.
No, we have no comments.
Then I move to approve.
Second.
I'd like to add to that, that if a jurisprudence exam is developed, it be added to the rule in a timely manner.
I accept that amendment.
Thank you. I did have a question for Director Courtney.
Certainly.
The testimony indicated that there is a test for gas fitters as part of their licensing procedure. Is that something that needs to be added or ought to be added? Or is it-
So I think the test, so the statute doesn't specifically require an examination, and that's what we were looking at as the statutory requirements. Interestingly, what we found during our analysis is that some boards, by either practice or rule, had established requirements that exceeded what was authorized by statute, and so that has facilitated some additional discussions. I think the examination piece is part of the actual program and the education requirements. So when we did the analysis, it wasn't a statutory requirement. That is feedback that I had not personally received. So I mean, we would be open to adding an examination, but our understanding is that the examination is at the conclusion of the course and is part and parcel of the course and is not a separate standardized examination.
Does the Mechanical Licensing Board have the authority to add requirements in addition to those in statute? Because some boards do, and I don't believe all of them do.
I don't know that answer off the top of my head, Representative.
Representative Groda?
So I do have a question. If, for example, there is a jurisprudence test that is accepted, how do it would be put in rules, and then you would come forward to, how does that happen? What's the mechanism for that?
So many boards have jurisprudence exams, and many boards have drafted them on their own. We've tried to get away from that and actually utilize experts in drafting tests because that's a specific technique. And what we do is we have a contract where we're moving all of those exams to a contractor to be able to allow the applicant to access the test at any given time. So they don't have to wait quarterly to take the examination. So the requirement to take the jurisprudence exam is put forth in rules, but the actual questions are not.
But the scope of the test is as specified by the board.
The scope of the test is specified by the board. A true jurisprudence exam will be about New Hampshire laws. What we've seen in reviewing some of the exams is that they're about New Hampshire law and then they're about the practice of the profession. So we're trying to get the boards to limit it to New Hampshire laws and specifically their rules.
Thank you. Other questions? Comments?
Thank you for your time.
Okay. Mr. Rancourt, you're wishing to testify and didn't bother to turn your card in earlier.
Thank you, Madam Chair. My name is Stephen Rancourt. I'm a licensed electrician in the state of New Hampshire and I represent the ECBA Electrical Contractors Business Association. From a procedural standpoint, I would just hope that the board would consider this, the committee, that we've been told, and many of us, that a lot of these things are not in our law. And Courtney is right. The executive director is right. If you look in the law, it's not in there. The procedure has been, for the 40 years I've been licensed, that you put the basic in the law, you define it in the rules. House Bill 594 or 554, which passed last year, which made these widespread changes, okay, happened, and now we're getting that kind of push back at us, but they didn't do anything to fix it. There's not been enough time to fix the laws. Many of the boards have the same thing, so I just hope the committee considers that, because we're putting this through saying, oh, it's not in the law, it's not in the law, because we didn't do anything. There's been no effort to try to fix the law. Just tell us it's not in it. We ran into the same thing with some education. We worked through some wording with them that isn't the best we want, but it was compromise, and that's what you have to do. But so there hasn't been any time to fix the rules and put the stuff in the law that they want. We're just looking at this legally when for 30 years or 40 years it's been like this. So maybe this committee, maybe the legislature can try to fix that. And before we just sweep through this, maybe look at addressing some of these, or at least going forward. I just think that we keep talking about it's not in the law, not in the law, but it never was. The change happened and now we're here. We never had time to fix the law. So
what sort of thing are you saying is not in the law that you believe needs to be in the licensing procedure for an electrician?
For an electrician in general, the continuing education is important. Like I said, there's a big gap there when that happens. We have 19 amendments right now with the electrical. So if they come in and they're not aware of them and they're not installing by them, we just had a situation in one of the town where somebody installed above and beyond the code because it was amended out, and now they're having troubles with it. I know you'll be surprised, arc faults, right? And so these are important to continue education for us. And again, we worked it out. There was a schooling hours. She did meet with the board, the executive director, and they came to an agreement. So what they did is we tried to list the schooling hours as a requirement with the substantially equivalent, which was less than what's required in our rules right now, but something that was substantially equivalent. And we were told we can't put it in there because our law doesn't say it. So the compromise was they put it into the top part, PLC 313.24 is the section for us, and they added it in, so it's part of the 8,000 hours now. So technically, they only need 7,400 hours of OJT and 560 hours of school, not the 8,000 hours of OJT and schooling. And I'm just giving you this as an example. So it goes throughout all of the boards and professions, as you've seen with the mechanical and stuff. It's not just us. We jumped ahead with House Bill 594 and then never gave it a chance to catch up, saying, okay, from now on, we need all these things in the law. Okay. Ours is clearly defined in rules, what the schooling requirement is, the board decides, how many hours, safety, blah, blah, blah. Previously, the legislature didn't want all that information in law because every time there's a little change, you got to come back to the legislature to do it. So I just would hope the committee considers that going forward to all this and take that into account before we just push it forward because it's not in our law.
I would say that having only 7,500 hours of hands-on work and 500 hours of education is substantially similar.
That's why we came to a compromise. I'm not disagreeing.
You know, we don't want to insist that we'll only accept people from states that have identical requirements. We want to say it covers the same material, it's substantially similar. That's,
But the education part is important with the,
that, and you made that point, and it's agreed.
yeah, but it's not in our laws because it wasn't necessary to be in the laws before. And I agree, substantially equivalent, we talked about defining that and there was much discussion about it. There is ways to be clear with that and make it very easy, but you can just put timeframes in. You know, if you've been licensed for 10 years, ours even has it in our RSA, I believe are the rules, that if you've been licensed for 10 years, that qualifies you to come and get reciprocal. You don't have to have all that stuff. So, you know, experience does count. In our particular section, it talks about they have to be licensed in their state for a year. So that covers the additional 2,000 hours that they would have. So that was why the compromise was made. And we appreciate Lindsay working with us and coming up with that. But just wanted you to realize that it's never going to be in the law because it's changed too fast. That's all. There's a lot going on. Thank you.
Okay, thank you for your testimony. Any other comments, questions? Mr. Evans, you wish to speak again?
Madam Chair, if I could for just a second, if you look at Mr. Evans' testimony on item number 1, he makes a recommendation to change the rules there. Currently, it requires that the licensing jurisdiction of the other state shall use the same edition or later of the same plumbing and fuel gas codes. I don't think that's exactly the same as the state building code and fire code that he has referenced in his recommendation for language.
Actually, the plumbing code is part of the state building code.
Okay,
And the gas code is, I believe, part of the state fire code.
perfect.
And we are in the process of updating both of those. Mr. Evans?
I just want to respond to a comment that the director made, that there is no authority for license examinations in the law. Under 15329, titled Examinations, Licenses, and it basically says the board shall establish through rulemaking pursuant to RSA 541A the nature of the examinations required for issuance of fuel gas fitter licenses and plumber's licenses. The scope of such examinations and the methods of procedure shall be prescribed by the board, and this may include an outside organization approved by the board. So they are required.
So what is that citation again, please?
I'm sorry. The citation is RSA 153:29, paragraph 1.
Okay. So has the board done so?
Yes. You can let the chair still here or not, but I think you would agree that we do license for all examinations, plumbing and gas fitting.
Okay.
So I was surprised to see that, and I was surprised to hear the director say that. That's all I have.
Okay,
you.
Director Courtney.
Lindsay Courtney, Executive Director, OPLC. I did not include this previously, but we are happy to modify 313.34 to specifically reference the actual RSAs. We're happy to do that. I agree that I think that's more transparent and easier for the public. With respect to the examination issue, I think the challenge that, and I'm happy to add pass a state approved examination, I think for gas fitters. The challenge is we don't have an actual, so we have a contract right now, and everybody who takes the examination for journeyman, for example, they go through that contract. It's a state standardized test. What I understand, and Mr. Evans can correct me if I'm wrong, is that the examination is given as part and parcel of the actual course. And so they may not, it's not necessarily one statewide exam that everybody has to take. If we want to add pass a state approved examination, we can do that for those who are endorsing in based on the RSA that he referenced. But I think that's currently the challenge. The scope of our contractual obligations for standardized tests does not include gas fitters. The other thing that I would mention, and just briefly, is I think what you're probably seeing is that as authority has shifted over the office, we're diving into the statutes and we're seeing that there's been some what I call regulatory drift. You know, there's been some historic practices that don't necessarily line up with statutory authority. And specific to electricians, for example, their statute authorized them to give credit toward the 8,000 hours for education, but it doesn't require education. And so when we are looking at the statutes in terms of what's substantially similar, we can't require that the other state require education because we don't require education. And that's been the historic practice, but that's actually a deviation from statute. I can't in good faith make an argument that we should just continue the practice. And so I think what we're currently working on is really trying to come together with the boards to clean up these historic practices that deviate from statute, either by changing the statute to be in accordance with the intent is, or by modifying the rules. But obviously that takes time.
Okay. Further comments, questions? Okay, we have a motion to approve the rule with the addition that the jurisprudence exam, once developed, will be included.
Madam Chair, did you
Yes.
want to add, Director Courtney had said that she was willing to amend to include the reference to the statutes in that section,
We should?
313.34.
Okay.
I'll make that motion if we need a
Amended.
motion.
Well, it's, all of, Senator Gray, you'll accept that?
Well, he's
He's left.
departed
Well, that is a shame.
on his behalf.
On his behalf, yes,
He'll
thank you.
accept it.
All right, any further comments, questions, discussion? Representative Fellows is in for Senator Gray since he stepped out.
May I just clarify, do you want me to add the state approved exam piece for gas fitters?
Can I just raise a question on that? I guess I have a concern that if we do that may be inconsistent with the sort of intent of the statute. In other words, and I obviously I have no expertise in this area, but the only analogy I can come to is the bar exam. If you say that we're going to allow people from other states to become lawyers in New Hampshire, as long as they take the bar exam, that's a big discouragement to having out-of-state lawyers come to New Hampshire. So I would think that it would be that the more appropriate thing would be that you, and I assume you've done this, you would look into what are the requirements in the other states to determine whether it's substantially similar. And for example, if you have to take an exam in New Hampshire, presumably you would, the other state that you're going to let somebody in, they would have an exam that it was generally similar to the exam you have to take in New Hampshire. I mean, is that the process you generally
Yes.
are following?
And that's what we did, and we did consult with the boards in determining the jurisdictions that are substantially similar, and we are reviewing them on an annual basis.
So I guess I would tend to think that the requirement that you take an exam might be inconsistent with the idea of the statute, if it's to encourage, allowing other out-of-staters to come in.
Particularly if the test in question is at the completion of the training. So it basically is the confirmation that you've completed the training rather than a separate test. As there is a separate test for plumbers and electricians.
Maybe what I can do is take this back, and when I talk to the board and work with the board on their jurisprudence exam issues with respect to plumbers, we can evaluate the gas fitters. I'm not sure moving forward in the future that's the model that they would like to use in terms of having the tests at the conclusion of the program. So we can work with them on that. I will say LNAs are very similar to that. So there is a model in New Hampshire for that.
Okay, thank you. Any further, Director Morrell?
I would add to, at least from a legal standpoint, if you put a requirement in that says you shall pass an exam and an exam doesn't currently exist, then they can't comply with that requirement. I mean, the
That's
committee,
why the request is that when the jurisprudence exam is available, it be added.
I know the committee has sometimes approved a rule that says you shall comply with this other rule, and the other rule is still a couple of months out. But, that's a case-by-case determination.
Okay. All right, any further comments?
To be clear, this is conditional approval based on the change in 313.34, which was adding the statute. And then with the understanding that when jurisprudence exams are added, they will be timely added to the rules.
Correct.
Okay.
Correct. All right, everyone understand?
Yep.
All right, those in favor?
Aye.
Those opposed? All right, thank you very much. And I'm really impressed we got this out in barely a year after we passed that law. All right. Department of Energy.
So this one is actually a conditional approval, and I worked with the department to come up with what they need. What they need is an oral conditional approval. That's to change in the very first paragraph of the rule. It says nothing in this rule or this part shall be construed, and it will be changed to nothing in this rule is to be construed. That's removing the shall because shalls do not belong in purpose statements. And then down on page 10 of the rule, in 150401B, we're also changing that may to a shall. So the department shall condition any license issued under this paragraph in any manner the department finds necessary to ensure that the license is likely to be exercised safely. Paragraph C is the same thing. We're changing the may to a shall. So using a non-adjudicative process, the Department of Energy shall reject incomplete or improperly filed applications. So those are the only changes that still need to be made. So this would be a conditional approval with the added oral conditional approval for this rule.
Okay, is there any other questions, comments? Is the agency here?
Good morning, Andrew Harmon with the Department of Energy.
Could you turn your microphone on, please? Thank you. There you go.
Is that better? Again, Andrew Harmon, Department of Energy, and I think there was just the intention to also state in C, it would say, and shall also using a non-adjudicative process, issue or deny a license within 90 days of receiving a, you know what, strike
says
that,
there
please.
already.
Yes, that's correct.
It's above that in C. What was left out was unless an application is cured upon request by the department. Just wanted to make sure that language was what was agreed upon.
Yes,
And
I
we
have
do
that.
we do agree entirely with the changes and would ask for an oral CA.
Okay.
I hope that was clear. I hope I made it more clear rather than less. Thank you.
All right, questions? Is there a motion?
So moved.
Second.
All right, moved by Senator Innes, second by Representative Lynn. Discussion? Those in favor?
Aye.
Opposed? Okay, there's energy. HHS.
So the final one on today's agenda is 2024-7 from the Department of Health and Human Services, treatment of specific types of income. The only comments I had on this proposal is that all of the section, except for 2 paragraphs, have been expired since June 12th of 2023. Section A, the only paragraph that remains is A7, but the whole section has to do with the types of income to be excluded for eligibility purposes. And Section B, which is all expired, is how certain types of income shall be treated. And then paragraph C, which is also expired, has to do with the treatment of supplemental security income, how that will not be counted or shall be counted as unearned income for FANF assistance. So that was the only comment I had on this proposal.
Good morning. I'm Nicole Valenzola, Department of Health and Human Services. Yes, regrettably, this is an example again where years ago you could open up just one paragraph and subparagraph and make an edit, and it alters the source note. And so, yes, Department of Health and Human Services did miss that, and when it was realized, began rulemaking. We're here if you have questions.
And have you enforced this rule while it
Yeah,
was
we
in
did
play?
continue business as usual. It was in the best interest of the client. There would have to have been an entire system overhaul with our programs and such. So business continued as usual. It was realized, rulemaking began, and we are here and do not plan to. We're glad that there's no longer opening up a paragraph or a subparagraph for editing and entire sections moving forward.
I believe some of these requirements are actually in federal law too.
Lovely. We all browse through federal laws on our spare time.
Yes.
Other questions, comments? Does somebody have a motion?
Second.
Okay, moved by Representative Leon, second by Representative Grota. Further discussion? Those in favor?
Aye.
Those opposed?
Thank
And
you.
I do hope you're scouring your rules for
We
similar cases.
yeah, I mean, honestly, we have 3,000 rules. There's 2 of us in the rules unit, and our program areas, of course, do rules in addition to everything else they do, but we are working very hard with every program area. It is sometimes really hard to catch these ones because when you're even looking at the source note, then you have to go and research the actual rule to find out which part was amended. It's not just there on Gen Court. So it's not our intention to let things expire.
Thank you. All right, anyone else? Do we have any other business? All right, well, Director?
No, nothing other than consideration of the continued meeting.
I don't think we need one. Does anyone? Okay, we will not have a continued meeting this month. All right. Anything else? In that case, we are adjourned.